Play stupid games, win stupid prizes. That's where we are right now. Because what we are watching unfold in real time is one of the most reckless, corrupt, and legally disastrous performances by a federal administration that I have ever seen. And yes, I am talking about the Trump regime, again. Because once again, they are proving that they are simply incapable of operating inside the rule of law. This is not politics. This is not ideology. This is not even policy. This is basic criminal procedure, constitutional law, and professional ethics, and they are failing all of it. Let's walk through what just happened because it's jaw-dropping. The Department of Homeland Security has a senior spokesperson named Tricia McLaughlin, and instead of doing what federal officials are legally required to do when the government is prosecuting someone, which is to shut up and let the court process play out, she decided to jump on social media and do something breathtakingly stupid. It started when a right-wing influencer named Benny Johnson falsely labeled Kilmar Abrego Garcia an MS-13 terrorist. His evidence? A TikTok video where Garcia is literally just listening to music. No statements about the case, no threats, no criminal conduct, just a man enjoying the fact that he is alive and free. And yet, he's being branded a terrorist. Then, Tricia McLaughlin reposts that defamatory garbage and adds her own attack. She claims DHS is under a gag order by an activist judge, while Garcia gets to make TikToks. She accuses the court of silencing law enforcement while amplifying those who oppose our legal system. That is not just wrong, that is illegal. There is no special gag order here. The judge simply said the DOJ must follow the standard rules that apply in every criminal case in America. You don't try to poison the jury pool, you don't defame the defendant, and you don't attack the court while you are litigating. That's it. And the Trump DOJ, along with DHS, just bulldozed straight through it. Let's be clear about what Garcia is and is not charged with. He is not charged with terrorism. He is not charged with MS-13 membership. He is not charged with gang activity. So when government officials go on social media calling him a terrorist, a gang member, or a wife-beater, that is not advocacy. That is jury tampering and defamation, and it's forbidden. Not by some liberal judge, not by some activist court, but by DOJ policy, local court rules, state ethics codes, and the Constitution itself. Every prosecutor in America knows this. And here's where it gets worse. Garcia's lawyers immediately went to court and flagged McLaughlin's post, and the judge didn't mince words. He said these statements prove that the government knows it has obligations and is violating them anyway. And then he dropped the hammer. The court pointed directly to Local Criminal Rule 2.01, which bars statements that create a clear and present danger to a fair trial. The government tried to argue that this rule violates the First Amendment. The judge rejected that outright. Why? Because the Supreme Court already ruled on this exact issue. In Gentile v. State of Nevada, the court held that restrictions on lawyer and government speech in criminal cases are constitutional when they are designed to protect fair trials. In other words, you do not get to wreck someone's right to a jury trial just because you have a Twitter account. The judge then cited McLaughlin by name. Her December 27th post was entered into the court record, and the court found that both her statements and those of the Border Patrol chief defamed Garcia and defamed the court itself. That matters, because this case was already in crisis before this happened. The judge in Tennessee, Judge Crenshaw, had already canceled the trial and ordered an evidentiary hearing because there was evidence of vindictive prosecution. That is not a technicality. That is one of the most serious findings a federal court can make. It means the government may be prosecuting someone not because of evidence, but because of political revenge. And then the sealed records were unsealed. What did they show? They showed that the acting U.S. attorney in Tennessee wasn't acting independently at all. He was taking marching orders from Main Justice, from the political appointees inside Trump's DOJ. Emails revealed that senior officials were coordinating the charges, the timing, and even the press releases. This wasn't a local prosecutor following the law. This was a top-down political hit job. And now DHS officials are pouring gasoline on it by publicly smearing the defendant and attacking the judge. That's why this has now escalated into sanctions territory. Federal judges do not like issuing sanctions. They bend over backward to avoid it. But when a party keeps violating court orders, at some point the judge has no choice. Because if the court doesn't enforce its own authority, it stops being a court. Harry Litman, a former top DOJ prosecutor, put it bluntly. Anyone who has ever worked in a U.S. attorney's office knows you cannot do this. You cannot try to dirty up a defendant while you are prosecuting them. That's not advocacy, that's sabotage. And remember, these aren't just any litigants. They are the United States government. The government is held to a higher standard than everyone else. Prosecutors are allowed to strike hard blows, but not foul ones. And calling a defendant a terrorist, a gang member, and a wife-beater when none of that is charged is about as foul as it gets. It poisons juries, it undermines due process, it threatens the legitimacy of the entire case, and it looks exactly like what Donald Trump did in his own criminal trials, violating gag orders, attacking judges, intimidating witnesses, and daring the courts to stop him. The difference now? Trump isn't just a defendant anymore. He's in charge of the people doing it. That is why this is so dangerous. Because when the White House adopts the criminal defendant's playbook, attack the judge, smear the accused, flood social media with lies, the entire justice system is put at risk. Judges across the country are watching this, and credibility, once lost, does not come back easily. So yes, play stupid games. If you are the Trump regime and think you can bully courts, defame defendants, and violate court rules with impunity, here is what happens next. You get evidentiary hearings, you get sanctions, you get contempt findings, you get cases thrown into chaos. And you have yourselves to blame. Because the law does not care who you voted for, the Constitution does not care who you worship, and federal judges do not care how many likes your tweet gets. This is not a reality show. This is a courtroom. And right now, the Trump administration is standing in front of it, daring the judge to pull the trigger. History shows how that ends, and it never ends well for the people who thought the rules didn't apply to them.